Hello and good afternoon. Welcome to the second webinar of our three-part series, which will provide an overview of the key construction contracting aspects relating to payment variations and time. And in particular, these webinars highlight best practice in relation to these aspects and provide an insight into avoiding disputes. This second webinar is focusing on variations, changes and compensation events under construction contracts. In particular, we will concentrate on any actions businesses can take in order to mitigate the likelihood of disputes occurring. Now, before we begin our formal webinar presentation, there are a few housekeeping matters to address. Firstly, if you would like to ask questions, please do so using the Ask a Question function. And in order to keep within the 30 minutes, we will answer as many questions as we can at the end, time permitting, rather than as we go along. And finally, a recording of this webinar will be sent out after the webinar is completed. So I'm Ian Drummond, a partner in Shepherd & Wedderburn, specialising in construction and engineering dispute resolution based in Edinburgh. And I'm joined by Chiara Pieri, a solicitor in our team. We regularly advise on a wide range of projects and have extensive experience in both advising on construction contracts and in managing construction disputes. So this understanding forms the basis of what we will share with you today. I will now pass you over to Chiara, who will run through the agenda for this afternoon's webinar.
Thanks, Ian. We will start by exploring variations and changes more generally, look at some common examples and introduce the concept of risk allocation. Thereafter, we will examine how specific kinds of contractual suites such as JCT and NEC deal with variations and risk events. We will then conclude with some best practice tips and advice on how you can manage variations and compensation events. We thought it would be helpful to firstly set out and explain the idea of variations and risk events, as these are concepts which do overlap and can cause some confusion. So what constitutes a variation? This term is usually understood to mean an agreed change to a contract. Applied to a construction contract specifically, a variation is usually understood to be an alteration to the original scope of works as outlined in the contract, such as changes in quantities, design and work conditions. Effectively, variations are extra work required under the contract, but this can also extend to substitutions and omissions of pieces of work. As many of you will have experienced firsthand, it is common for construction projects to vary in some way. Any changes from the original tender design, specification or drawings will normally constitute a variation. Variations are sometimes necessary due to the very nature of construction and engineering works. For example, the employer's needs may change. The contractor may discover something about the works which means extra or different work is needed, and it may transpire that the agreed work cannot be carried out. One of the fundamental aims of construction contracts is to appropriately apportion risk between parties. A straightforward approach is to delineate risk according to which party is best placed to manage the occurrence of an event. Therefore, if an event is within the control of the contractor, they will not be recompensed for such an event. The employer will then be liable for events within its own control, such as employer-led variations, as we have just discussed, but also other employer-caused events, such as delays in giving the contractor access to or possession of the site. A third category of events then exists, termed neutral events, which can be described as events not caused by the fault of either party. These include factors such as exceptionally adverse weather conditions and those falling within the category of force majeure, such as a change in law. In relation to these events, it is less clear who should bear any ensuing time and cost impacts, and we shall see later that there are differences in the approach taken by JCT and NEC. So following that reminder as to the basis of variations and risk events, let's take a look at how the most common types of construction contracts deal with them.
Thank you, Chiara. Now, the first suite of contracts we will discuss today is the JCT or SBCC suite. As most of you will be aware, SBCC is generally simply the Scottish version of the JCT suite, and so we will use these terms interchangeably. We will focus on the JCT 2016 standard building contract without quantities, and so if you are using a previous version or different version with quantities or a design and build contract, you may find some differences. Also, it is important to note that we are discussing these conditions in their standard form without amendments. So, how does JCT deal with variations and any delay or additional cost that flow from these? Well, the crucial point to note is that JCT differentiates between what it calls relevant events, which entitle the contractor to claim additional time, and relevant matters, which entitle the contractor to claim additional costs. The provisions dealing with relevant events can be found from clause 2.26 to 2.29 of the JCT Standard Building Contract 2016, and these are relatively wide in scope. Relevant events are those that cause delay to works and in principle entitle the contractor to claim an extension of time to completion, effectively meaning that the agreed completion date is amended. Relevant events include variations and factors within the control of the employer, such as delay in access to the site. However, relevant events also include neutral events, such as adverse weather conditions and loss or damage caused by a specified peril. Examples of specified perils can be found at clause 6.8, and they include factors such as fire, floods and riots or civil commotion. Therefore, if such an event occurs, the contractor is entitled in principle to be awarded an extension of time, but would not normally receive any additional funds to cover the cost of being on site for longer than planned due to those events. Due to the extension of time award, the contractor will be exempt from any liquidated damages for delay provisions that might have applied given the original completion date was not met. In comparison, however, the definition of relevant matters at clause 4.21 is relatively narrow in scope. A relevant matter is an event which the employer is responsible for and which materially affects the progress of the works. A relevant matter will include variations under the terms of the contract, which the Standard Building Contract of the 2016 suite calls variations, but note that the Design and Build version calls them changes. Relevant matters will also include impediments caused by the employer, such as a failure to give the contractor possession of the site, delays in receiving instructions, and discrepancies in the contract documents. These will generally entitle the contractor to claim additional costs for the works.
JCT 2016 has separate but similar provisions for the notification of variations, relevant events and relevant matters, which can be found in section 5, 2.24 and 4.20 respectively. So what must parties do if they think that the works may be delayed as a result of a relevant event or relevant matter? For a relevant event, the contractor is obliged to notify the architect or contract administrator when it becomes reasonably apparent to the contractor that progress of the works is being or is likely to be delayed. Therefore, JCT does encourage notification prior to the event actually occurring. However, it must be noted that while the contractor is under an express obligation to notify the architect or contract administrator of the occurrence of a relevant event, that is, delaying progress or is likely to delay progress, there is no contractual consequence for the contractor if they fail to do so. The position is different for a relevant matter, which includes a variation or change under the design and build contract. Notification must be given for a relevant matter, and the contractor's entitlement to financial compensation, known as direct loss and expense, is expressed to be dependent on this. With this notification, the contractor ought to provide an initial assessment of the loss and or expense incurred. Variations under JCT may be valued by an agreement between the contractor and client, or a variation quotation prepared by the contractor and accepted by the client. Broadly, JCT provides that valuations for variations will be based upon the rates and prices provided by the contractor in their tender if the work is of a similar nature and carried out in similar conditions. This calculation will be based on what kind of contract you are operating, for example by using the rates and quantities in a bill of quantities. Where work is not of a similar character, clause 5.6.2 specifies that it shall be valued at fair rates and prices. This value can either be agreed by parties or ascertained by a quantity surveyor. The contractor will be asked by the architect or contract administrator to provide a quotation in accordance with the provisions of Schedule 2. If this is accepted, the contract sum will then be adjusted accordingly. Before we move on, it is worth noting that Schedule 2 also deals with acceleration quotations. In JCT, acceleration occurs where a contractor's work needs to be expedited to complete a particular work activity earlier than planned, or if there have been delays and the original deadline is required to be met. The quotation must identify the amount of time that will be saved and note the impact on the contract sum. The process is similar for other relevant matters. Following notification of the event, there will be an initial assessment carried out by the contractor as to the loss and expense incurred, which can be adjusted on a monthly basis until the total amount of the loss has been supplied. Within 28 days of the initial assessment and 14 days of the subsequent updates, the architect, contract administrator or quantity surveyor will then ascertain the amount of the actual loss and expense and compare this to the quotation from the contractor. Amounts ascertained are then added to the contract sum. In terms of relevant events, as soon as possible after notification, the contractor should give particulars of the expected delay. On receiving this, the architect or contract administrator will then ascertain if the delay constitutes a relevant event and will impact upon completion. If this is the case, they can give an extension of time and the completion date will be amended accordingly. We won't spend too much time on this process today, as the next webinar in this series will deal with time events in more detail. In our experience, assessing and valuing time and cost events can be a very complex and contentious process. Therefore, it must be noted that there is no substitute for familiarising yourself with the provisions in your contract which concern these, in particular any amendments to the standard form provisions. The key question in respect of delay is whether the delay event has caused or will cause delay to subsequent activities and ultimately impact upon the completion date of the works. Such complexity is compounded in cases of concurrent delay, where more than one event occurs simultaneously, but where they do not all enable the contractor to either claim for an extension of time of additional payment, or additional payment, as both parties have been at fault. In our experience, often cases are decided according to a detailed exploration of causation, as well as an analysis of the specific contractual provisions in each case and any amendments that may have been made. Now we'll move on to discuss how the NEC suite deals with variations and changes and risk events.
Now, as Chiara has just discussed, JCT does encourage parties to notify one another of events when they first occur. However, there are no sanctions for failure to do so in respect of delay, that is, in respect of a failure to notify a relevant event, because that will not ordinarily remove the contractor's entitlement to extension of time. But by contrast, a failure to notify a relevant matter is likely to remove an entitlement to loss and expense that might otherwise have arisen. But in comparison, NEC operates firstly an early warning mechanism as a risk management tool embodying the NEC philosophy of early identification and resolution of problems. Under Clause 16 of NEC 3, an early warning notice must be issued as soon as a party becomes aware of any matter which could increase the total of the prices, delay completion, delay meeting a key date, or impair the performance of the subcontract works in use. Now, emphasis here needs to be placed on the word could, because this means that the contractor must notify even if it is unclear that there will be an increase in price or if there will be a delay. Additionally, the contractor may give early warning of anything that could increase total cost. These early warnings are then entered onto the risk register, and an early warning meeting should be held to discuss how to either avoid or mitigate the effect of such an event on the project. It can also be helpful to have planned periodic meetings throughout the life cycle of the project to assess ongoing risks which are named on the risk register. Now, it is important to remember, however, that under NEC, early warnings are not intended to apportion blame, but rather to collaboratively discuss steps to address the event. In other words, the early warning provisions are about risk management. They are not about allocation of responsibility or liability. Additionally, failure to address in practice an early warning will probably lead to a costlier outcome for both parties in terms of future compensation events. Now, Clause 16 regarding early warnings does apply to both parties, but contractors should be especially mindful of the requirement to notify an early warning, because if they fail to do so, then their entitlement to compensation for a compensation event in future will be assessed on the assumed basis that they did give an early warning, whether they did in fact or not, allowing mitigation steps to be taken. Thus, if the impact of the compensation event could have been mitigated had an early warning notice been given, then the contractor will be denied compensation to that extent. Now, we don't have enough time today to discuss NEC 4 in detail, but it is worth noting that there have been some subtle changes to the early warning mechanism regarding the risk register, which is now more appropriately termed Early Warning Register under NEC 4, and the role of the project manager is also changed because he may now also give notice of any matter which could increase the total contractor's cost. So let's now take a look at how NEC deals with valuations and risk events as compensation events.
Thanks, Ian. Firstly, it is important to note that NEC early warning mechanisms operate quite separately to the compensation event mechanism. Indeed, NEC combines JCT's relevant matters and events into one concept called compensation events, which entitle the contractor to claim both additional time and additional costs in relation to completion of the works. Therefore, compensation events deal with classical variations, i.e. alterations by the client, as well as any other changes that cause delay or extra cost. It must be noted that compensation events are limited exclusively to those listed in the contract. If an event is not one of those listed in the contract, a claim should not be submitted, even if this has led to a delay in the works or additional costs. So where should you look in your contract to find this list? Under NEC 3, these are contained in Clause 60.1, and there are 19 specific events listed. Take care when identifying what the most appropriate compensation event is, as there is the possibility that the notification will fall if notified under the wrong clause. There is no danger in listing all the compensation events that may apply. NEC 3 deals with compensation events through a four-step process: notification, quotation, assessment and implementation, which we will briefly discuss in turn. It is crucial to act in accordance with the specified notification procedure under NEC for a compensation event arising from an instruction of the project manager, who is the contract administrator under NEC. The project manager must notify the contractor and instruct them to provide a quotation. For all other compensation events, the contractor will have 8 weeks to notify the project manager from the point that they become aware of an event that constitutes a compensation event. Following this, the project manager has 1 week to consider and agree whether the event constitutes a compensation event. Common reasons for rejecting the event are if it is caused by the fault of the contractor, has no effect on the defined cost or completion date, or is not one of the events listed in the contract. Quotations can be quite a complex process. In many cases, it will still be unclear what the true impact of the event will be. In this case, the project manager must set out the assumptions the quote shall be based on. If this turns out to be inaccurate, it may constitute a second compensation event. It is possible for the contractor to ask for multiple quotations for alternative methods of dealing with the event, and this allows the project manager to choose next steps that suit the business's requirements. The quote is then assessed using the procedures specified in Clause 63. One of NEC's key principles is that neither party should unfairly gain from a compensation event. Therefore, where the contract includes activity schedule or a bill of quantities, the assessment is based upon the effect of the event on the contractor's costs, called defined cost. This varies from the JCT suite, where events are assessed generally according to contract rates or modified rates based on these. The fourth and final stage is implementation, which is when a compensation event is concluded, and this cannot be overridden unless by the decision of an adjudicator. Importantly, it should be noted that sanctions do apply if parties fail to comply with certain aspects of this process. The first scenario is where the contractor fails to notify the project manager of a compensation event within 8 weeks of them becoming aware of the event. If this deadline is missed, the claim will be time barred and the contractor will not be entitled to a change in price or completion date. Be aware that this is one of the most heavily amended areas of NEC contracts, and so a 3 or 4 week notification period is commonly specified. The second sanction arises where the project manager fails to reply to a quotation within the allowed time. The contractor can notify the project manager of the failure, and if the project manager fails to take further action for an additional 2 week period, deemed acceptance of the quotation will occur. Just before we move on today, you should be aware that acceleration has a narrower meaning in NEC contracts and does not include where acceleration is in order to meet the original completion date because of delays. It is where the completion date is being brought forward. We shall discuss this further in our next webinar.
Now, we are focusing on NEC 3 principally today, as that is what most parties are still using for the time being. However, there are a couple of important changes between NEC 3 and 4 that we thought it would be worth pointing out in the context of our topic today. The first is that a new concept of the dividing date has been introduced into Clause 63.1, which should make it easier to claim and to assess compensation events. This new date is intended to solve the problem of which accepted program a compensation event should be implemented against. The 4-step process of notification, quotation, assessment and implementation under NEC can take a considerable length of time, and it is common during that time for revised programs to have been issued and perhaps accepted. This raises the question of what program should ultimately be used to assess the compensation event. Well, the new provision states that the dividing date will be either the date of the communication of the instruction or notification by the project manager, or, for other types of compensation events, the date of notification of the compensation event. A further change is that 2 additional compensation events have been added to the list at Clause 60.1. The first is for obtaining a quotation for a proposed instruction, which is then not used. This might counter a situation, for example, where the contractor is asked to quote for a possible change instruction and to pause progress on a part of work that would be affected by the instruction, where that instruction is then not proceeded with. It is also to try to prevent project managers from abusing the quotation process, which can be costly for contractors. The second additional event is to incorporate any new events added in the Contract Data Part 1 section of the contract. Now, this allows parties to alter the standard risk profile in NEC 4 without the need for any amendment to specific clauses. That is, the additional compensation events added in Contract Data Part 1 can be listed there, but this second additional event will give effect to those without the compensation event clause having to be further amended. As always, if you are concerned by any specific clauses within your contract, please do take advice to address your specific contract and issue. Now, as we've seen today, there are some important differences in the way that JCT and NEC handle risk events. But how do these differences manifest in reality? Well, let's take a look at how both suites deal with extreme weather conditions impacting on the completion date of the works. The first major difference is that this is only a relevant event under JCT, not a relevant matter, and therefore the contractor would ordinarily only be entitled to an extension of time rather than be recompensed for any loss and expense. This is in contrast to NEC, where contractors will ordinarily be entitled to both extra time and money. A second key difference is that JCT 2016 does not precisely define extreme weather, referring only to exceptionally adverse weather conditions. The contract administrator, therefore, in the first instance, is given quite a wide discretionary remit, which can result in an increased likelihood of disputes. In comparison, NEC 3 contains detailed and relatively mechanical provisions which define extreme weather as weather that across the calendar month has occurred on average less frequently than once in 10 years, according to a specific weather measurement location. So as a consequence, extreme weather under NEC will normally need to have occurred for an extended period of time to create an entitlement to a compensation event. This mechanism also means that under NEC, ascertaining whether an event has occurred will be more objective in nature and arguably gives greater certainty than the position under JCT. So Chiara will now briefly conclude today's webinar with some best practice tips and advice.
Thanks, Ian. So how can you mitigate against adverse effects of changes and variations? Our first tip is that prevention is better than cure. Do your best to eliminate any uncertainties before contract award. This can be done by undertaking thorough site investigations, ensuring that designs are properly coordinated before tender, and that drawings, bills of quantities and specifications provide for all situations that are reasonably foreseeable. However, be aware that even after taking all of these early measures, variations are still likely to arise at one point or another. Therefore, you should familiarise yourself with this section of your contract and be aware of any steps or deadlines that you may have to take and adhere to. For instance, failure to notify an early warning, and particularly a compensation event under the NEC suite, can have dramatic effects upon the funds a contractor may be entitled to. Furthermore, notices need to be in the correct form as prescribed by your contract. Additionally, be aware that although the timings we have discussed today are relevant to the standard forms, it is very common for these to be amended by parties. Therefore, please make sure you review amendments to your contract and take note of the impact of these changes. No matter what contract you are operating, working collaboratively and proactively to remedy variations and risk events should be encouraged. Clients should seek to discuss changes early with the contractor, and likewise, contractors should notify the client of delays and other issues as soon as possible. Try to use such mechanisms contemporaneously, as leaving the assessment or consideration of events until later can be considerably more difficult, especially for time events. Lastly, as discussed earlier, if disputes occur in respect of a delay, it will normally be required to show causation, or in other words, that the event impacted upon the final completion date. Therefore, it is imperative to keep detailed records. Carrying out a critical path analysis can be helpful, but the courts will usually take a practical, common sense and evidence-based approach, and have expressed their dislike for complex delay analysis exercises, which have been criticised as too theory-based.
In conclusion, because of the complexity of construction projects, it is rare for them to be completed exactly according to the original agreed provisions, scope and completion date. Therefore, it is essential that there is an adequate and workable mechanism for dealing effectively with such events, and that this is followed by both parties. As processes do vary between the different suites of contracts, it is definitely worth becoming familiar with these provisions. But if you are ever in doubt about a specific event, we urge you to seek advice as soon as possible. So that concludes our formal presentation. We have a minute or so to answer any questions. So if you haven't already done so, please type any questions into the Ask a Question function. Just while you're doing that, I would take the opportunity to remind you that our next webinar will be on the 10th of December, and that one focuses on programs and time. Also, our first webinar in this series, which dealt with payments and valuations, is available to listen back to on our website, YouTube and Vimeo. So if you wish to access those, please do so. So we have one question. We've probably just got time to deal with one question in any event, and that is whether the list of compensation events under the NEC standard form provision is often varied. And my answer to that would be, we do find that being commonly varied, and in particular that's often in relation to the weather and physical conditions, which is the ground conditions compensation event. So we often see those two compensation events actually quite often being removed altogether. Now obviously that depends on the intended risk allocation under the contract, and obviously if the employer in the example of ground conditions is intending that the contractor carries the risk for those, then it would be suitable for that compensation event to be removed. However, of course, the correlation to that is that will likely drive up the contractor's tender price, because it will have to include, or will normally include, a risk premium for the removal of those compensation events. So I think that's something for employers to be aware of. They can, of course, change the allocation of risk that the drafters of the NEC contracts have provided for, but that's likely to drive up tender prices, because risk premiums will then be included for those. So I think that's probably all we have time for. So thanks very much to all of you for listening. We're grateful that you've done so, and we will now conclude the seminar. And just as a reminder, a recording will be sent around shortly after this webinar is completed. Thank you.